Good afternoon, everyone. I'm Oghenekevwe Harrison, the Delta State lead of the Nigerian Bar Association Women's Forum. I welcome you to this second quarter webinar where we'll be learning on mediation as the new frontier for the female lawyer. We have our chairperson here present. Chairperson, you're most welcome. We appreciate your support. We also welcome all here present. Thank you for taking out time to come in and learn of the topic. We have our two guests already waiting to unleash. We have Uduak Udofia. She is a legal practitioner with over 20 years of experience in corporate commercial law and alternative dispute resolution. Also, the second guest speaker, Oghenekevwe Orighoyegha. She's a PhD student in Bournemouth University, United Kingdom. She's a fellow of the Institute of Chartered Mediators and Conciliators, and also a member of Chartered Institute of Arbitration, United Kingdom. She is a corporate lawyer with, she worked as a corporate lawyer with Shell Development Company Nigeria Limited before she joined the judiciary, the Delta State Judiciary, as the dispute resolution officer before she left the shores to further her education. I believe with the topic and with topic they'll be sharing quality knowledge on the subject to us, and I pray that whatever we'll learn as we take them and apply them, it will work in our hands and will be seen out there as having been empowered by the Nigerian Bar Association Women's Forum. May I at this point welcome our chairperson, Chinyere Okorocha, to give us a short speech before we kick off. Over to you, Madam Chair. Madam Chair, over to you.
Yes, I was trying to unmute. Good afternoon, everybody. And thank you so much for joining the Delta State chapter of the Nigerian Bar Association Women Forum for this webinar. It's the second webinar for the year, I believe.
Yes, ma'am.
I truly want to congratulate the Delta State lead, Augustina Harrison, and her team for putting together this interesting, what promises to be an interesting and informative event. The truth of the matter is that webinars have become a way of life in the corporate world today, in the professional environment, because it affords you the ability to learn whilst being in the confines of your office. And so I'm so delighted today at the webinar being hosted by the Delta State chapter of the NBA Women Forum. Now, the topic up for discussion today is mediation, the new frontier to be explored by female lawyers. Again, mediation, the new frontier to be explored by female lawyers. Now, when I look at this topic, the part of it that shouts out at me is exploring something new. And this is on all fours of what we try to imbibe in the Nigeria Bar Association Women's Forum, where we are all about empowering ourselves for success. And so how do you empower yourself as a female lawyer in Nigeria? And one of the ways to gain more knowledge, more professional prowess, such that assuming you are in an environment where there may be some sort of discrimination or being overlooked for roles, by the time you arm yourself with new frontiers in the law or the practice of law, when opportunities arise, it's those people who have equipped themselves that will be the ones that will be in the line to be chosen for career advancements, to be chosen for new opportunities. Now, mediation isn't really new in Nigeria, but for a lot of the female lawyers, I've been doing a tour of the country. In recent times, we were in Abia, we were in Imo, we were in Bayelsa, we've been to Port Harcourt. We're going to Ibadan next week, or your state, and the upper week we're going to Kano next week. The upper week we're going to Ibadan, then Abuja. You know, and one thing that strikes me in all this is that female lawyers are hungry for knowledge. In a lot of the jurisdictions that I have mentioned, and so many others in the 36 states of the country, a lot of us, we just rely on litigation and then perhaps the Ministry of Justice. But the focus of the NBA Women's Forum is fivefold. The 5 areas where a Nigerian female lawyer can practice her law. And those are where our membership is drawn from: the bench, the bar, academia, in-house counsel, and the public sector. These are the 5 areas where you can actually, as a female lawyer, develop your career. And these are the 5 areas that we, as the Nigerian Bar Association Women Forum, have chosen to play. And we encourage you that no one area is better than the other. No one area is juicier or more interesting than the other. Wherever it is you find yourself, make it and turn it into what you want it to be. If you are in academia, aim to rise to the very top. As you all know, Professor Oluyemisi Bamboshe, the immediate past chairperson of the forum, she is in academia, and she decided to create a career where she actually rose to the top of her career as a female lawyer. So at the moment, she actually, from being a lecturer, fulfilled the requirements to become a senior advocate of Nigeria. And she's one of the few female lawyers that have been given the SAN shape through her academic prowess. So why can't that be you if you decide to go the academia route? We also have female lawyers that are in-house counsel. We have them as our members, practicing as in-house counsel in big corporations and making a difference. Some of them actually rise to the stage of becoming general counsel in these big conglomerates. But whether it is a big company or indeed a small one, why can't it be you that rises to the top of the food chain, even in a corporation? You see, women were very, very able to adapt to situations and to change what could be an ordinary career into an extraordinary one. Or you could be in the public sector, working in the Ministry of Justice, and so on and so forth. How can you make a difference? How can you stand out from the crowd such that if an opportunity to become the next PAM secretary arises, that you get chosen? All these are choices that we as female lawyers have to take. Some of us are just in the profession because, you know, maybe our husbands say we must work, or we just want to support. But I dare say that there are a few of us that actually want to make a career of being a female lawyer, and those are the people I'm speaking to today. You can stand out from the crowd. You can change your career into whatever it is you want it to be, such that other opportunities come your way. For example, I'll give myself as an example. I'm an intellectual property practitioner. That's what I've done for the past 33 years. Servicing clients both nationally and internationally. That led me to the opportunities to travel abroad for intellectual property conferences, exposing myself to international best practices, gaining new experiences, you know, mixing with other people, and bringing that knowledge back to my law firm. I'm now very adept at, you know, mingling with international people. But you wouldn't have thought that as a lawyer, that's one of the requirements. But through my experiences in all those countries, I got singled out. Why am I the one that was made the chairperson of the NBA Women's Forum? I didn't lobby for it. I didn't lobby to be vice chairperson in 2019 when I was vice. Somebody heard about me and said, oh, she'll be a good fit for that opportunity. And that's how it happened. So women, I'm here to tell you today, wherever it is you find yourself, do your job to the best of your ability. Be the very best that you can be. I am well aware that women have limitations because we, apart from being professionals working in a career, we also have that distinguished role of being wives and being mothers. And sometimes it can affect the practice of the law or whatever career you've chosen to be. But there are ways that you can make sure that you get the best of both worlds. If I can do it, you can do it too. To the glory of God, I have 3 children, and they're doing well by God's grace. That can be you tomorrow. But I have still maintained my career. I'm still recognized in the legal space, as an expert in my field. And that's what I want for every woman who is a member of the Nigerian Bar Association. So I want us all to take today's training very, very seriously. I think it's indeed a privilege that we're able to come to webinars like this. We don't pay, we didn't pay to be here, but we're going to learn something new that can help us in our careers because no knowledge is lost. A lot of people talk about litigation, but not so many people are members, would I say, are adept at the mediation part of it. And today I'm all ears. I'm not a mediator. I hear about it from the side. I guess my knowledge will be that the one I learned in school, maybe in the law school, when we touched on it. So I'm very interested to hear from the experts today. I'm also interested to know what kind of certifications I may need if I want to go into mediation, apart from being a lawyer or going to the law school. As I wind down and I close, if you are a member of the NBA Women's Forum, then you know who we are and what we do. But if you happen to have come across the link and you have joined and you are not a member of the NBA Women's Forum, I want to encourage you to join us today. The NBA Women's Forum is a constitutionally inaugurated arm of the NBA, just like the sections and other fora were created to cater to the needs of the Nigerian female lawyer. This we do by holding empowering programs like this, networking amongst ourselves, exchanging ideas, also partnering with international and other local or national female lawyer associations, to empower ourselves. We're all about empowering ourselves as female lawyers to ensure that we can get to the height of our careers. I should also mention that most people in Nigeria know about the FIDA Female Lawyer Association. We are not FIDA. We are different from FIDA in the sense that FIDA, Nigeria and internationally cater to the needs of disadvantaged women and children in particular, whilst NBA Women's Forum caters to the needs of female lawyers in particular. And that's the major difference. And so all our programs are aimed towards empowering ourselves for success. FIDA is our sister body. Lots of the members in NBAWF are also members of FIDA and vice versa. We are not quarreling. We're not in competition. I think that with a population of over 200 million, out of which maybe 200,000 are lawyers, the world is big enough, So I want to encourage you. If you are a member of FIDA, you can also belong to NBA Women's Forum. And if you're a member of NBA Women's Forum, you can also be a member of FIDA and any other female-led association that you may want to be a part of. So in the Women's Forum, we have committees, about 11 committees. You can join any of the committees which focus on different areas of interest to us: advocacy, external relations, mentorship, welfare, in-house council committee, corporate council committee, public sector committee, quite a few of them. Of course, fundraising, we can't do anything without money. It's also a subcommittee, and about 11 of them all together. Media and publicity, I shouldn't forget that. We also have what we call state leads in each of the 36 states of the country, including Abuja. So the state leads supervise what we call the branch facilitators, and we have over 125 branch facilitators in the 125 branches of the NBA. And so that's it. Once again, I want to commend Augusta Harrison and her entire team at the Delta State chapter of the Nigerian Bar Association Women Forum for putting together what promises to be a very interesting and informative webinar. I'm sitting back to listen. If you want any information about the forum, I'm sure that the administrator may be on this call. Please put our website in the box so that anybody can reach out to a phone number that people can reach out to get more information about membership. I should mention before I go that the membership of the forum is a token 5,000 Naira for anybody who is 6 years and above at the bar, whilst it's absolutely free for everyone who is a new wig up until that 6th year. So 0 to 5 years, it's free, and 6 years and above, it is 5,000 Naira. So once again, thank you everybody for being here. If you just crave my indulgence and do one more thing before I leave, I would like each of you to take the link of this webinar and post it on your own networks. This is a great opportunity to learn. Don't learn alone. Indulge me, copy the link for this conference or this webinar and post it on your network, send to your female lawyer friends to come and join you to learn something that can help them in their careers. So thank you everybody for coming, and have a wonderful outing today. Back to you, Augustina.
Thank you, Madam Chair. That was a very nice intro and enlightenment on the Nigerian Bar Association Women's Forum. Without much ado, we'd like to bring to the fore no other than my friend, Uduak Udofia. I actually met her at one of the NBA Women's Forum conferences, and since then we've bonded like nothing else. The floor is over to you, Uduak.
Thank you so very much, Agustina. Thank you, Madam Chairperson, for that wonderful keynote address. Good afternoon, everybody. Good afternoon, my co-speaker, Kewe. It's my pleasure to be here today. I want to find out, can I share my screen from here, or would you do it from your end? Because I sent you the slides. What is possible? Should I try? Okay, so the host has disabled my ability to share. So how do we do it?
Okay,
Will you send it to Wanne?
Wanne has received it. I'm sure she's working on it already.
All right. Okay. So, like I said, I'm very happy to have this opportunity to share. And I thank God for NBAWF, because it's also another place you meet vibrant women, like-minded sisters, like Tina. Because we actually met during one of our conferences. So today I'll be speaking to us on the topic for today, mediation, the new frontier for women lawyers. So Wanne, please, you'll be working with me so that once I tell you to move to the next slide, we'll be able to move quickly. I want to know in the house, how many people are mediators, or you have an idea about mediation? You can just raise your hand up. Let me just have an idea. Can I see? I've not seen any has. Okay, so that means most of us don't have. Oh, okay, Oluwabomi is a mediator. She has an idea of mediation. Fantastic. Okay, any other person? Okay. I'm going to talk today about mediation, the basic skills of mediation, what you need, the stages, and then I'll also do like a little bit of overview of, okay, maybe some women that have gone into this mediation space and they are doing wonderfully well. Someone like me, I must confess, I didn't start up, actually started up as an arbitrator. But when I got into that space, I was like, no way, this thing looks too much like litigation. It's just private litigation. And a friend now said, oh, why don't you consider mediation? And that's how I found myself in mediation. And it became my sweet spot. Wanda, please, can we move to the next slide? Thank you. So we'll talk about introduction to mediation, the benefits of mediation, the role of the female lawyer in mediation, and then some case studies and conclusion. Please, the next slide. Okay, so what is mediation? Simply put, mediation is a process. It's a process whereby parties come together with the help of a neutral third party to resolve their disputes. One thing we should know is that it is a voluntary process. Once you take away voluntary from that dynamics, then that is no more mediation. There are certain principles we need to consider when we begin to talk about mediation. And these principles, a sound understanding of these principles would help you to be a sound mediator because they are all important. Oh, beautiful. Okay, I've seen from Martina. Fantastic. Consent is number one. Remember, we said voluntary is a key word. So where there is no consent to come into mediate, then you can't call that process a mediation process. And sometimes it can also be a bit tricky to really establish consent because, you know, at times our judicial system to the courts would actually order you to come into mediation. Are we aware of that? Some high procedure rules actually say, oh, go to mediation first. And as a mediator, when you are faced with that kind of a scenario, one of the first things you really need to establish is that you've gotten the consent of the people, because they might walk away and say, that was not mediation. And truly, if you can't establish consent, there's no mediation. The second principle you need to consider is confidentiality. And for me, that is what really makes mediation unique and very, very, you know, separate and distinct from litigation. You know, in litigation, most times it is in the open court, and then people that have a business or do not have a business, in your case, they are sitting there and everybody knows what's going on in every other person's business. In mediation is not so because of the confidentiality principle. Confidentiality is very key in that if you take it away from the mediation process, it erodes from the whole process. It makes people to lose, you know, confidence in that process. We'll talk more about confidentiality as we proceed, but we also have to understand this other principle to neutrality and impartiality. I mean, there was once we had an argument about, can you truly be neutral? Let's ask ourselves, are we truly neutral? The truth of the matter is that everybody has one inclination or the other. We all have our little biases here and there. But what makes it different for you as a mediator is that you have been trained and you understand that when it comes to mediation, you are supposed to be impartial. You are supposed to put away your biases and be seen as being neutral and impartial in the process. Because once it is shown that you're not neutral or you're impartial, it can actually erode from, you know, the trust of the parties in the mediation process. That's why it's also good as a mediator. Sometimes you might be called upon to do a matter, and if you think that, you know, you might not be able to do it because of one reason or the other, that maybe you might affect your ability to be impartial, you can always let it go. In fact, I actually had an experience like that once, and I was like, I don't want to go into too many details, but you see, some people entered into a funny contract that actually bordered on human trafficking. That was part of the substance, and they actually brought it to mediation. And number one, I was like, excuse me, who does this? This is actually illegal. Of course, we made them realize that, but they kept saying they had a contract and I sent my own daughter out. Now it's your turn to send your own daughter out. How come you are reneging? I don't know if you get that picture. So it was so funny. And I was like, no, I can't even sit in this. Number one, it's illegal. People realize it's illegal. But my head of department then was like, well, let's hear them out. At least let's give a listening ear. But I know we could not mediate in that process because we knew, number one, it was fundamentally against the law. And we could not be seen to be impartial. Mediation is a self-determining process in the sense that parties themselves are the ones that come up with their solutions. Remember, your role as a mediator is not to take over the matter. It's not to tell them what to do. Your role there is to facilitate the discussion between the parties, to help the parties, of course, bearing in mind these principles and others we'll be sharing as we go forward, and other techniques we'll infuse into the process to come up with a mutually acceptable or bearable solution that they can go home with. And of course, we should know it's not every time that mediation process actually ends with an agreement, because that's one of the things too I had to get used to, because some people feel, oh, we didn't come up with an agreement in this session, and that means we didn't do well as mediators. No. If you've not done anything, you've helped parties to talk. You've helped them to understand what are their positions, their interests, their needs, and all of that, regardless of the fact that maybe you've not been able to arrive at a mutually acceptable agreement. Wande, please, the next slide. Next slide, please, Wande. Okay, thank you. Wande, is it possible to take away this window that is saying host disabled participant screen sharing? I think it's from your end. It's covering part of the slide. Okay, don't worry, I think it's from my end, done. Okay, so now what does a typical mediation cycle look like? I prefer to call it a mediation cycle. Some people call it stages of mediation, but I think at the end of the day, you actually see it is more of a cycle, because it is not like straight jackets from here, you are sure you are getting to this. Sometimes you get up to one process, and before you know it, the party brings you back to another stage, and you realize you've gone back maybe to stage 2 or stage 3. Meanwhile, all the work you've put in, you're thinking, oh, we are getting towards the bargaining phase and getting to the closure phase. Number one, I feel is very important. Some people say they have 7 stages. Some people say they have 5 stages. I mean, it doesn't really matter as far as you are able to do what is expected of you as a mediator sitting in a mediation process. I feel that this pre-mediation entry point, understanding it is very, very important. In fact, I never understood the importance of the pre-mediation entry phase until I went for my negotiation training at the Netherlands Institute of International Relations. That's when we had a discussion, and one of our facilitators asked us, okay, those of you that they actually give you cases because it's been ordered or that they come, do you think that was actually voluntary? It's court ordered. How do you now establish the consent of the parties and the trust, to build the trust in you and to see you as being impartial? Do you understand? So sometimes you have to really look at the entry point. How did you get to sit there as a mediator? It's beautiful if the parties had actually had it in a clause. Let's assume it was a contractual agreement and there was a clause for alternative dispute resolution that had mediation provided for. Fantastic. So that one you already know, okay, consent is actually established. So you need to understand your entry point and you seek to also solidify on that and to build trust, so that once they have a trust in you as a mediator, they'll be able to trust the process and you're likely to also get a positive result out of the entire process. And the next thing I believe we should also have there at the back of our minds is a pre-mediation process, the case intake. Who receives the matter? For some of us that maybe you've worked for, like, let's call it like an organization that actually makes somebody to sit down. They have a case manager and the person takes down the case. Sometimes the case intake is not done properly. That's one of the things that, some of my experience. And you're like, hey, we know the people that are actually sitting to take in the case, most of them are actually not trained as mediators. So you have to come back, you look at the file. In your pre-mediation readiness, how was the case reported? Who are the parties that should be before you? And then you also sit down and actually analyze what are the contents of this mediation before me. That will require another set of skills, your conflict analysis skills. We'll talk a little bit more about conflict analysis skills later. Stage 3 is the agenda setting. Let's assume, okay, you've established the entry points, you make sure your entry point is solid in the process, and the parties believe in your role as a mediator, and they trust the process, and they come in. Remember, it's a voluntary process. One of the things you need to do is to help them to set the agenda. Remember, we say mediation is party-driven, and the parties that are driving the process, some of them have never been in a mediation session before. So you also have the duty, the responsibility to let them know what to expect from a mediation session. You explain the stages that you're likely going to, have in the mediation session. How who will speak first? Is it the person that brought the matter, the complainant? How many minutes will you assign to each person? Okay, you narrow down on the issues, because some parties will come, they can come with 1, 2, 3 issues, but as they begin the mediation process, they want to start packing other things into the agenda. No, you have to be very firm. We've agreed today we are doing A, B, C, D. Are we on the same page? And they say yes. You get your consent. Most times it's always smarter and advisable to get your consent in writing. That's why there's what we call agreement to mediate. Some people will just have a little sheet of paper that just says, we've agreed to bring our matter to mediation, and the sign. In fact, I've had a mediation session where parties refuse to sign agreement to mediate. And then I said, there is no mediation. We're not ready to proceed, because as a mediator, once you cannot show that you've established the agreement to mediate, you can't establish the consent, and you'll just be wasting your time. Some say, no, just go on, I'm not signing anything. And my lawyer says I shouldn't sign anything. So that speaks to us. Some of us are lawyers, so at times you don't really advise our clients properly that mediation is not litigation. It's a different kettle of fish entirely. And at times, it's difficult to take away the lawyer hat and put on the mediator's hat, but it's possible, because some of us are still lawyers, excuse me, and at the same time, we also sit as mediators. So you have to establish the consent. Then you know who are your parties. And the parties before you, do they have the authority to mediate? That's another very tricky thing. Some people can actually come. And if you want to do a good job as a mediator, for instance, it's a company, and maybe an individual. For a company to come, it has to be somebody that is at least at the managerial level that can take decision, because the essence of this mediation process is to be able to resolve a dispute. Not that you are having a session towards the end, hey, no, I didn't have authority to enter into agreement. How? You have to establish that the parties before you actually have the capacity and the authority to enter into an agreement with you, with the other party, as a result of the mediation process. Wande, please, can I have the slides back? Okay. Wande, can we have the slides back? So we've spoken to, being sure who are the parties before you, having the consent, having the authority, and how you can actually secure and make sure that you have your consent. Then you actually go into the mediation process proper. The opening statement is very crucial, and that is your role as a mediator. You have to be sure that that opening session actually sets the tone. part of what would help you, I really must even go back again. In your agenda setting, it's good to agree on your ground rules. Because if you fail to agree on your ground rules, most likely your mediation process will derail. Do you understand? Because some people are actually mischievous. Some parties can be mischievous. They've come in, they know they don't want to mediate, but they just want to be there so that they'll be seen that we came to the room. They say, which especially maybe the court-ordered ones. And halfway through, they start bringing up attitudes and some kind of tactics that derails the mediation process. So if you've not been able to capture your ground rules from the onset, you'll not be able to actually navigate that situation. So it's important, you too as a mediator, remember it's not your process. You are there to help them. You are there to facilitate the process. It's always good not just to come up with a sheet, here are my ground rules, I'm the mediator. No, it's good to have their buy-in. Let them also contribute to what they think should make part of the ground rules. Of course, still make sure that you're in charge of the process as a mediator. So for instance, let me use one very clear example. We had a session once, and after we were told that some people actually recorded the session. Remember that goes to the foundation of confidentiality. And it's wrong. Because you start, oh, we agree, we switch off our phones. Yes, some people say, oh, I've switched it off already before I came here. I said, no, turn it on. As I'm turning off my own in front of you, I'm also seeing you turning off your own in front of me, and we keep the phones away. Because what happened was later, somebody came back and played the entire mediation process, and oh, it was not a good experience. So it is important you know the things you agree to, and you're also firm to use your ground rules to make sure that your process does not derail. So you go into your opening statement. Normally, that's where you set the tone. And if you have your skills top-notch, already you would have already analyzed the matter before you. You already would know the disposition of the parties, and you know the best way to do your opening in such a way that you get them to relax and to trust the process. Another thing too, as you moderate, you learn to give everybody equal airtime, because some people can be very finicky. If we say this party, after my opening, the complainant can use 5 minutes to state their matter briefly. You might find out that somebody will use 10 minutes. I'll say, I have not finished. No, I'm still on it. But you now tell them, no, we agreed everybody has 5 minutes each way. So once you're done with their opening and they've done their presentation, one of the things a good mediator is expected to do, you should always remember your conflict analysis tools. There are so many of them, but I just mentioned like 2. Remember, there's one we call the PIN model. Some call it PIN-P. In fact, I learned that PIN-P in the Netherlands too. But when we were trained at multi-law quarters, we just taught the PIN model. The PIN stands for the position, the P, position, I, interest, and needs. So if you can use your PIN model very well as they are stating their case, sometimes what they put as their complaint is not even the real issue. But you can only know that as a mediator, as the process goes on, you are applying your tools to say, fine, this is the position they are taking. Okay, this is what they say they want, but this is actually where their interest lies. You are noting it. And this is actually their needs. Most times the needs are the non-negotiables. But if you're experienced, you'll be able to know how you can layer on making parties understand that at the negotiation phase, I'm sure Kevin will talk more about that. You can actually gain some and lose some. It's a win-win. It is not a lose-lose. You win a bit here, you shift grounds a little bit here. That's the whole essence of mediation. You can equally use another tool called the onion model, and that onion model actually applies you as a mediator. You have to have very good questioning skills, active listening skills. So you apply it as the mediation process is going on. Sometimes, of course, you would have done the work. You'll be very surprised at the work you would have done, maybe with the brief of the case you were given. Once you get into the mediation process, if you're active, you're seeing it unfolding, maybe in a very different dynamic way, and you keep applying your tools so that will help you when you get to this next stage that we call the exploration phase. That is actually where the work I feel that is where the work of the mediator really is. Because at that point, that's when you actually need to learn how to ask them open-ended questions, probe further. And most times we use what we call the caucus session. From my experience, I realized that if you don't even tell parties up front that you may decide to caucus as the process goes on, they will like, hey, why are you taking this person away? No, this party, oh, they are taking sides. No, but you let them know most times if you want to really get to the crux of the issue, you need to go into caucus, meaning that you have to meet the parties separately. Oh, I'd like to meet with you briefly for so time. I also make sure you also meet with the other person briefly or the other set of parties briefly. Also listen to them. What you're doing in your caucus, most times you get better results than when they're in the joint session. That is when they actually open up. Some will say, it's not really that land I need. I just want an apology. Yes. In fact, there was a matter, yes, like that. It was like the setting was an extended family setting. And I think what happened was that we had 2 elder daughters and a younger son from like a concubine. Long and short, the boy felt he was not recognized in the family and he was posing a lot of issues. Of course, he was going after the elder sister's properties and all of that. And there was a lot of issue in that family. And when they came, that was one particular mediation process. I saw that most times it's not really about, I want the land. He just wanted to have a sense of belonging in the family. He wanted to be recognized as a son. And in that session, we were able to call, because they had done a partitioning before, and there was a Baba, like the head of the family, an octogenarian, a man in his 80s. Because the first thing I was like, why will I have to call this man to come? But since they kept saying, when they shared, this is what, and I said, was anybody that was there present when this sharing, partitioning was done? Is the person still available? They say, yes, the daddy is available, like the head of the family, not their real father. And I sent for the Baba. And immediately the old gentleman came in. It was as if they poured them water. All the fighting that they've been doing in previous sessions, they stopped. Number one, the Baba just said, this is what was shared. And the boy said, yes, he knows, but it's just because they have been treating him like an outcast. And it was simple, we were able to resolve. So sometimes, if you do not probe further, it was because I called the boy and I was probing what's really happening. And he said, this is what is happening. It's not even the land is interested. He wants to be seen as a part of the family. So in your probing, your caucusing sessions, you can actually do a lot of work to fast track your mediation process. If you do a lot of good work in your caucus session, you'll find out that you come back into your joint session and what you're doing is to begin to bargain. You begin to trade-offs. Okay, let me be recognized as a son in this family. I'll stop going after your property. I'll just stay within the family house, the portion that was given to me. And it was very easy. At that time, you also have to learn to know the cultural context, the nuances. You understand? I could do that because I was like, these people, since they're Yoruba speaking and I know they respect elders a lot, if I can just lean into that. In fact, the mediation session that was supposed to take, it looked like a session that would take more than 4 sessions or 5. We finished it in the second session, and everybody was surprised. Do you understand? So this happens, things like this can happen if you learn how to use your skills as a mediator appropriately, looking at the circumstances before you and being creative, because you have to be creative. Because sometimes when people are so stuck in their position, they can't think. It's like they have a mental block. So you're the one to make proposals. Remember, you're not telling them this is what you do. No. Yeah, saying, can you try this? Can we try this? And when they begin to bargain, another very important thing is summarization. Is a skill that you use at the face of bargaining. Because what happens, people actually make a lot of trade-offs. And if they are making the trade-offs, you are not noting it as a mediator. Sometimes you can lose some grounds because they'll say, okay, I will do this if it does this. You say, okay, did you say you do this? Say, okay, fine. Okay, this person has said, I will do this. Are you willing to consider this? Remember, it's still the way you approach them with your creative, questioning skills. And once they agree on certain points, you summarize and then you move on. And if you use some of the tools, like for instance, we have what we call ZOPA. It's just an acronym for the Zone of Possible Agreement. What happens is that as you're going on in a mediation process, you know, remember your position, interests, and your needs. Each party, they have theirs. But as you're listening, you could see where sometimes you begin to have an overlap of the position, the interest, or the needs of the parties. And even if they don't overlap, what kind of, they are related. So you could make them see, oh, have you seen, this is what you're saying. So if this is what you're saying, it means if you do this and someone does this, then that means it's possible who can look at how you can make this work out. Sometimes they wouldn't see it, but you, the mediator, should begin to see it as your process is going on. And you help them to make trade-offs that they are comfortable with. Because some, like I said, will be so stuck in their position, they will not know how to shift from their position to look at what saves their interest and then what speaks to their needs. And the final stage is the closure phase. It is very important that you understand how to close properly, because sometimes, could not lie, a mediation session can be draining emotionally. You're listening a lot, you're thinking a lot, and at the same time, you're trying to be creative to help these people come up with solutions that they may consider. So sometimes you might find that towards the end of the mediation process, you're really tired, mentally tired, emotionally, physically, and you might forget to close your mediation session properly. You shouldn't fall into that trap, because that will derail you completely. All the work you have put in, the time, the energy will be wasted. How do you close properly? Let them summarize and let them say with their mouth, because that's one thing I've seen. If you summarize for them and they don't say it with their mouth, okay, I said this. This is what you said. When I heard you say this, you say yes. Okay, please say it back to me. So you've said, yes, I am saying, they will say back. I say, okay, fine. So we've agreed on that point. You note it. So you're beginning to get your agreement. So mediation is not that difficult. It's an interesting process. And sometimes you should understand this process most times doesn't just flow like that. Sometimes you come to exploration and they bring a new issue and you have to consider, do I want to introduce that issue or it? Because it was not part of the set agenda for that day. So that's what a typical mediation session most times would look like. And you know, since mediation is always confidential, you keep reminding them that anything that has been agreed is not supposed to be taken outside of the session. It cannot be used against you. It cannot be used against any of the parties, even if they decide to go on litigation, because sometimes they may agree on certain aspects of their disputes and some aspects will still be hanging. And they might decide, okay, these other parties will still want to litigate. Okay, so can we move to the next slide? Thank you. All right, so benefits of mediation. We already know that most time it actually saves time. I think typically, if you were to compare the time, let's use the scenario I just painted. If those people had gone to court entitled to land, average, how many years would they stay? They will stay for a lot of years in that court, because most times they'll not get any decision in that year the matter was filed. But in a mediation session, you can actually get your decision or your resolution same day, depending on how complex your mediation is. And it is less expensive for the parties. Do you understand? And it preserves the relationship, especially for people in business, because you still need to be in business with that partner, or you still need to maintain that family relationship. Then mediation is something you should actually consider. And it helps parties to create a solution. Remember, it's a party-driven process. It is not like in the court where it's the judge that says, this is my ruling, or this is my decision, this is my judgment. All of you say, as the court pleases. No. Mediation, they contributed to arriving at their decision. So most times they feel that sense of, I co-created this, therefore I can uphold this, and I'll make sure this agreement works. I can actually get an enforceable agreement from a mediation session, because that's what most people fear. How can I enforce this? Yes, you can, provided you go and get it signed and stamped and sometimes entered as a consent judgment in the court. It's enforceable. And above all, mediation is a transferable skill. It's a skill that you can use in any way, in your relationships, in your home. Do you understand? Can we move to the next slide, please? So what's the role of the female lawyers in mediation? They have a unique perspectives and skills. In fact, the dynamics of you being a female mediator is that most times you're more perceptive of the power dynamics in the room. That's the truth. You know where the power tilts. You know, when people come, sometimes it's a power play. Because I can do this, I'll make sure you suffer. So your role as a female mediator is to know how to diffuse that. Sometimes it could be with just a simple arrangement, like seating arrangement. You're supposed to diffuse the power dynamics and make everybody feel equal, heard, and seen. And of course, most times we are also very sensitive to cultural nuances. In fact, a female mediator friend of mine was sharing her experience. She had a mediation session, and she noticed the people, one of the parties was looking at her in a very displeased manner. So she now noticed, I think they're from the sex that they cover up everywhere. So she said, okay, fine. She made sure that when she's going for her next mediation session, she wore a long kaftan. So that if it is that's what's going to make you comfortable and accept me as a mediator, I'll do it. You understand? So of course, they're also sensitive, very gender sensitive to the dynamics. For instance, if you're handling a lot of domestic violence issues, you should know already as a female mediator that the power imbalance in the home most times is tilted to one way. Sometimes it could be to the woman or to the man. So you should see and know who has the power, greater power in this relationship. And you know that there's no how two of them are in the same room and they'll be able to come to a mutually agreeable solution. So sometimes you just take that party away first and cut us and say, are you really here to find a solution? Or are you here to do gra-gra? Let's say in our Nigerian parlance, you know. So you are sensitive to these things. And I think the most important thing is as a lawyer, we understand that we have our unique set of skills with our training and exposure, your critical thinking skill, your analysis skills, your research skills, and a lot more. So these are the things, of course, you infuse or pivot a bit into your mediation, practice. Because I found out, mediation is open to everybody. But I found out that any lawyer that truly wants to excel in mediation, they actually do better because they are able to transfer some of the skills they're already using in the legal space, but not utilizing it like we do in litigation in a very abrasive, harsh manner, but to use it to help the parties. Sometimes some parties don't even know how to articulate their issues. So sometimes in the caucus, that's when you're going to help them. You see, so what do you really want? Is it this one or is it this other one? Okay, if you get this one, will that make you okay? Do you understand? You help them to articulate their issues. And this is where you're using your critical thinking skills, you're using your communication skills. Okay, let's move. I think let's move to the next slide, please. I want to just talk about quick case studies and examples in the domestic and the humanitarian setting of, people, women that have excelled in the mediation and peace building space. Like I said, I started first of all as an arbitrator, then I said, no, let me come to mediation. And of course, I was doing a lot of civil, domestic mediation until somebody also showed me that, there's this other side of the coin. So I realized as a mediator that you can actually practice and work anywhere. That's the truth. But as a lawyer, if you don't go and take their bar exams and all of that, you cannot practice in their jurisdiction, true or false. So as a mediator, your skills are, I think for me, they are more marketable. And you can actually use those skills in different settings, in humanitarian settings, in conflict situations. Like I'm talking about like interstate, at the national, regional level, which sometimes if we're just sticking with yours, maybe I just want to do litigation. These are some of the opportunities that might not be open to you. For instance, this lady, Alice Ndiritu, she is a Kenyan. But I found one thing because we've been in a same forum together where she was sharing her experience, mediation experience and all. I realized she actually mediated the peace process in, these just, clashes and Kaduna clashes. She was invited in initially as a co-mediator. but she had an entry point that was unique. She used to use a lot of humor, and she was able to get the traditional communities to actually sit and listen to her. So these are some of, we use our feminine disposition to be able to also get access and get some of this job done for us. For instance, she used to tell them, oh, you see, people are fighting too much, so the men cannot even settle your issues. So she used humor and say, I've come and I've brought tea from Kenya. Oh yeah, people should come and drink tea, special tea. And from there, she was able to open up dialogue. She helped the women communities, the women's, communities in that, in those settings to be able to have a strong constituency to articulate their issues and say, if we have this, we should be able to have a more sustainable, peaceful, community. She could do this because, number one, I believe because she was a woman, and most importantly, she had a background in human rights. And human rights is part of what we also push as being part of NBA. We push for the rule of law. And then as a female lawyer, of course, you have the extra age. Like Betty Bigombe, she's a Ugandan, and she is one lady that I saw could actually pivot in her career. She started off as a nurse, but she now got into peace building work. Of course, before you know it, she was able to build and leverage on her career. And she was able to help to broker peace when Uganda was having their civil war. She actually went to speak with the rebels. And of course, from my own insight and experience at CMC, the Citizens Mediation Center, because that's another thing, I was offering my services for free because I was like, I've trained as a mediator. And if I don't use these skills, if you don't use it, you lose it. That's what they say. I said, I might as well just go and be volunteering. But I got a lot of experience and exposure in mediation. Just going once a week, I was able to have like how many hours in mediation and cases to my own credits, such that when we had this opportunity to apply to be part of African Network of Women in Conflict Prevention and Mediation, all those experiences counted because they want to know, you've trained, what have you been doing? So please, this is also like a call out to some of us. You've trained, but you're looking for an opportunity. You're looking for the big one. The big one might not meet you until you go first and volunteer. And then you also have to learn to leverage and pivot some of the skills you already have. For instance, a lot of you I know, like our chairperson said, you're a member of FIDA. Do you understand that most of the work you do in FIDA speaks to the protection pillar? There's what we call the Women, Peace and Security Agenda. It's a UN Resolution 1325, passed in 2000. So if you can just position all the work you've been doing under that framework, number one, you can get a lot of funding for your research. You want to go back to school, you want to, build on your skills and your, maybe look at another area of your career. All the work you've been doing, if you put your volunteering work together, it can give you an opening. And once you get into that space, these are the fantastic thing. Women, female lawyers, I see they always excel because naturally their critical thinking skill is top notch. Their drafting skill is quite good too. So these are the things when other people are learning, hey, how do we draft a peace agreement? You will be remembering your constitutional law. Remember your legal drafting skill lessons. So I think as I wrap up, I need us to understand we need to be part of networks. So if you are interested in mediation, please get certified. There are so many bodies that certify. Multi-door courthouses in most of the states, they certify. The Women, my own organization, we have academy coming up that is actually teaching you not just mediation skills, but peace building skills, so it can be relevant not just in the national space, even regional and internationally. Then you also have the ICMC, so many bodies, CEDAR, outside of here, they are certifying. And just once you get your certification, please go and put your skills to work and learn to be part of vibrant networks. Thank you very much.
Wow, that was a wonderful one. Thank you, Uduak, for the exposition. We have gained a lot. Without much ado, we'll have to move on to Kewe. So please, if you have questions, you can pen them down and you can put them down in the chat box. At the end of the lectures, we'll deal with the questions. So over to you, Kewe Orighoyegha. Sorry, I always put the other one in my head.
It's okay. Good afternoon, everyone.
That's
It's good to feel like I'm back home, honestly. Actually, I'm just so excited listening to us talk. It's been a while. Thank you, Tina, for this opportunity and the shelf person, NBA Women Forum. It's a privilege to be in the same webinar with you. And I want to use this opportunity to appreciate my DJ. I just saw him now. I think he's here around. His Worship Nandi Oyenkwe Esquire, the Delta State Multi-Docket House Director General. He's a wonderful person, and to everyone here. So without wasting much time, let me quickly go to what I have thought to do today. And so I'm going to talk briefly on, can you hear me? I'm clear enough.
yes, yeah.
Okay, so I'm going to talk on the techniques and strategy of mediation, and I'll talk about the challenges of mediation, ethical consideration in mediation, and future trend in mediation. And so, first of all, I want to also appreciate, I think lastly, I want to appreciate Uduak. She did a very good research, a very good talk. And at the time I was thinking, do I still have anything to say? Because she has really said a lot that I want to say, but I'll just run through some of what she has said, and in agreement, we'll just flow through the process. And so, like she mentioned, stages of mediation. Actually, the first thing to think of when you're thinking about mediation are the stages of mediation. And mediation can happen at any stage of the dispute. So it could be before they go to court, and usually at the Delta State Multi-Docket House, they say it's a working matter. The matter is not yet pending in court. And it could also be when the matter is pending in court, or even after conclusion of the case. That's after judgment has been given in the case. We could also mediate on the matter. So mediation can be done pre a court proceeding and even post the court proceeding. So just to buttress that point, during court proceeding, if for Delta State Civil Procedure Rules, Order 25, Order 25 to see provide for pretrial conference, and it states that the judge can promote amicable settlement of the case or adopt an ADR proceeding into resolving that case during pretrial proceeding. And also Order 29 1C also provides for the judge with the consent of the party. And I know Uduak said that so much, like without the consent of the party, there is no mediation. So you need mediation, you need the consent of the party to mediate. And so Order 29 1C of the Delta State Civil Procedure Rules also provide that the judge with the consent of the party may encourage them to settle their disputes using mediation. And so mediation any of the parties can apply for the case to be mediated. And so you don't need all the consent of all the parties. If any parties, especially when they're in courts, signify interest to resolve the matter using mediation, the court will call the attention of the other parties and want them to. So you don't need everybody to agree at the first stage. And if it's a working matter, you get somebody will always commence the process and from there. And so usually you don't compare, you don't coerce, you have to persuade. Even the courts will not compare, we only persuade them or, guide them to accepting mediation as a means of resolving their disputes. Now, I want to talk about four stages of mediation. And so I'm going to talk about the preliminary stage, the preparation stage, the mediation stage, and the post-mediation stage. I know Uduak has thrown more light on that, but I'll just run through it quickly. So usually at the preliminary stage, you get the claimants. In Delta State, we retain the name, the parties are already in court. We retain the name they use in court. For example, you have the claimant and the defendant, and so we also use that name. We don't need to change the name you get. And for a working case, you use applicants and respondents. So for court-referred cases, we use claimant and defendant as they were, or the name as it was in the court. And so usually one of the parties come to approach the multi-docket house or approach a mediator to say, I want my matter resolved using mediation or using any other method. I don't know what to do. I'm having a problem. I'm having a challenge with XYZ and I want you to resolve. So that's the preliminary stage. So there's an approach to either the mediator or to the multi-law court house. And we'll move to the pre-mediation meeting, which is the pre-mediation stage. Once the party comes, the next thing we'll do is we get them to draft it, just because you are already in a we're going to have a formal sittings, informal but formal. So it has to be documented. You need to be sure that they have the consent, that they really want to do what they want to do. And so you get them to, at the preparation stage, you do pre-mediation meeting, and in that meeting, at the preliminary stage, after the party has approached you and has filed the process, you have to notify the defendants or the respondents, as the case may be, informing them that their issue has been brought before you, and you intend to see how we could look at it to get it resolved. And you also send them a copy of the process, and also fix a date that will be acceptable by all parties to sit down and have a pre-mediation setting where we could all look at it and agree on some terms. And so usually at that meeting, you get the parties to exchange documents if they have other documents to exchange besides what they filed at the multi-law court at with the mediator. They also agree on the venue. And usually it's in that meeting you discuss issues of the mediators if they don't have any in mind. So you could give them the profiles of the mediators you have, say, oh, we have XYZ, this is the profile of this mediator. Whom do you think? Because it's always been like, mediation is a party-driven process, and so the parties are in charge of the process. So you always have to allow them decide who they want to mediate over there. You don't compare them to a particular mediator. So you tell them these are the persons who want. Most times they really don't have an idea. They don't really mind. Anybody can be. When they have a problem, if this person is okay. Then most times I think mediators, parties tends towards women. I don't know, especially when you are handling a family-related dispute. So they feel I think women will understand better. Some others prefer the men, but most times I discover that most parties prefer women mediating in their cases, probably because of our God-given talents beside our legal experiences. And so in that meeting, you have the timing, you agree on the time, the dates, the fees, if there are fees to be paid. That's when you inform them that this is what it's going to cost. And they also agree on who to attend the meeting. Like Uduak rightly said, it's not a public sitting. In mediation sitting, one of the advantages is a private, confidential sitting, and so it's not open to the public. And so the parties agree, oh, I'm going to have XYZ attending the mediation sitting, and the other party also agree. And so there's an agreement on who should be in the mediation meeting and who shouldn't be in the meeting. And so there's also, in the case where a party is coming in the representative authority, you need to make sure that that party have an authority to mediate, a consent from the people is representing. So we have more of that in company-related cases, communal issues, family issues where everybody cannot come, and so you just need somebody to, so you will insist on ensuring they come. Otherwise, the entire process is a nullity if there is no consent of authority. So we will discuss that as we proceed further. And you also let them know that there may be need for caucusing. The essence of caucusing is to have a private meeting of each of the party, and there may be other things you guys want to discuss, or the party might feel more comfortable to discuss with just the mediator. And so you also let them know, and also let them know the rules of caucusing. So they don't feel like, what are we going to have, what kind of meeting are you going to have with him, and what are you guys going to discuss? And so you let them know, if I'm going to have a caucusing, for fairness sake, I will also want to have with you if there is need for, except you don't want it to be. And these are the rules for caucusing. So usually at the pre-mediation stage, you set down the rules, you agree on so many things. You let them know the nature of privacy, so they don't come tomorrow and come with a crowd of people and say, oh, no, you cannot, everybody cannot attend, and they are offended. So they already know at that pre-meeting that everybody cannot attend. You have to delegate who will attend, and that person will have to come with a letter of authority. And you also have to, usually for us in Delta State Multi-Law Court House, we discuss about confidentiality, and we get them to sign the confidentiality form. I will get them to sign the confidentiality form, and the mediation process in detail, just let them understand what the process looks like, because it's new in Nigeria, and so most people are not really aware of it, and you don't want them to come thinking is another litigation they're trying to come. So you need to get them on the ground running. And so that's basically what you do at the preparation stage. Then after that, you move to the mediation stage, which is properly the date fixed or agreed by all parties for mediation. So there must be an agreement. Somehow you have to, as a mediator, you have to keep down your tools just to make sure the parties are flowing. And so sometimes it can be very inconveniencing, but that's the role of a mediator. It can be very savvy. And so there's an agreement on a date, they agreed on venue, they agreed on time, and so you don't impose any of this on them. So we get everybody like, oh, what do you think? How do you think? So you do a lot of open-ended questions. You don't just, what I'm saying this, no. We do a lot of open-ended questions, we ask questions, we get them to fill it up. So it's very interesting. You will learn that if you really want to go into mediation. So at the mediation, you start with an opening statement. So your opening statement, you want to introduce yourself, you want to introduce the parties since you already know them, like I didn't say this, but in mediation stage, you also want to know what do you want us to call you, what name, what title. You don't want to offend anyone in the process of mediating. You don't want to start talking and say, sorry, I'm a chief. You didn't call me a chief. Oh, I'm a doctor. You have to call me a doctor. I don't joke with my title. We love titles in Nigeria. And so you want to be sure, what name do you want me to call you for the purpose of this sitting? What name do you want me to call you? Also tell them the name you want to be called. Most times just your name. Don't care where I'm going. It's like simple. And so you agree on that, and you start the opening statement. You inform, you introduce yourself, introduce the parties that are there, and you tell them your intention, your role, that you are going to facilitate settlement and communication and settlement by the parties. So basically, it's not your settlement, it's your settlement, but you are there to help them to communicate. You're going to assist them or facilitate them into communicating and also reaching their own agreement that is acceptable by them. Sometimes it can be very funny because sometimes even the agreement might not be so nice in your mind, but that's what they want. And so you don't have an option. You just allow them to do what they want to do. Yeah. And you also discuss on some of the ethics, like you talked about impartiality. You let them understand the confidential nature. You let them understand that it's voluntary. And so painfully, you can walk away from mediation at any stage. And that's one most painful part. That even after, until the parties sign, there's nothing binding any party. So it's voluntary. That's voluntary. So you just let them understand that it's voluntary. If you don't feel like you want to continue the process, please feel free to let us know, and we'll allow you working. We're not going to force you, we're not going to tie with them. And you also agree on the ground rules. So before I talk about the ground rules, you allow, so everybody will agree on the dates they want the case to be fixed. So there's an agreement on what day should be fixed, what time, like I mentioned before. And also you allow the parties to present their case, a summary of what they've already filed before you or what they've already sent to you. And so you allow them to discuss, you give them. So but before that, you set down the hello. Hi Tina, can you hear me?
Yes, yes. We are
Okay.
Yes,
hearing
we
you.
can hear you.
Okay, thank you. And so before that, you set down the ground rule. So the essence of the ground rule is actually you set as a behavior which is expected for all parties. And so it's not actually you setting down the ground rule, but you telling them that, I want us to have an agreement on what rules will guide us in this mediation, And so most times you start by saying, I'm going to start, for me, I always say, you see me taking down notes. And the essence of taking down notes is not because I'm writing a judgment or because I'm trying to get evidences against anyone to use to make a judgment. No, but just to help my brain, so that when some kind of points are being said, I want to just put it down to help me remember what you said and help me flow along with you. So that because sometimes you don't let them understand why you're writing down a note, they feel a little bit uncomfortable. So I'm like, oh, you're not saying, I'll be talking like you're not writing. Some mediators wants to write like as he's talking, you're taking every word. No, sometimes it's not always the best. Like for my practice, I was told that's not the best. And you need to allow you just put down the salient point that will help you to remember and recall what you said. And you also let them know that at the end of the sitting, you're going to trash it, so you're not going to use the notes for anything. If they agree, whatever they agree becomes what is binding on them. There's no agreement. Everybody walk away, arguing themselves or not arguing themselves, but there is nothing happened, and they continue their life the way they came, like nothing happened thereafter. And also, in one of the other ground rule you discuss is timing. What time do we come? Then you also discuss on issues on taking turns to talk. You don't want them to be talking all at the same time. And so you try to tell them like, okay, so we're going to allow you to take turns. So when this person let's say party A is saying something, you don't need to interrupt. So you give them, for me, our practice in the multi-dot delta state is you give them a piece of papers, you give them biros, and just let them know that you can put them whatever he's saying that you don't agree with instead of interrupting. So you are not allowed to interrupt, you are not allowed to be talking at the same time with the other person. When it's your turn to discuss, you can now start from whichever mood you want to. And also you get them to agree on how many minutes they want to use to present their case. And so some will just say, oh, I think 10 minutes is okay for me. And I'm like, oh, I think I will need like an hour or 2 hours, whatever. So they just, there's an agreement like 1 hour. Do you think, oh, this was like, okay, I think I'll need 30 minutes, I'll need 15 minutes. So there's an agreement. So you also agree on, you also let them know that they can take a break or can ask for adjournment if they are feeling uneasy or becoming tiring or they need to go for school runs or there's something emergency. You should just call your attention, they would take a break. And also you agree on no use of abusive or aggressive languages because, usually in mediation, tempers can be very high because you're getting the people together. These are people that have been having conflicts and sometimes for years they've not been able to see them face to face, and another beautiful thing about mediation is it's not like a court setting where everybody is far, the lawyers are the ones talking, the parties are just there. This one, you're going to talk your case, you're going to talk yourself, and you're going to sit on a round table. So you're sitting down, facing yourself, eyeball to eyeball, discussing your issues by yourself with the help of the mediator facilitating the process. And so you get them to understand this is how it's going to look like. But sometimes when they don't know this thing, when they come for the day of mediation, they'll tell you, oh no, I don't think I want to do anything here. Oh, I didn't know I'm going to sit with oh, I didn't know I'm going to sit with him, especially if it's a family dispute. I can never. So you get them prepared for what is going to come. I also appeal to them not to use abusive languages, then to be respectful for each other. I've talked about the issue of caucusing. And so at the mediation, you should seek to understand their position. So usually you find out that they have their position and they have their interest. And so mediation basically will treat more, guiding them to discuss their interests, because most times if you sit on position, then you actually go into litigation because you want to insist this is my right. Everybody feels I'm right. Everyone is feeling you're right. So sometimes you just, get them to talk more on what their interest is. Like I think it's Uduak that mentioned, or the chair mentioned something about, drifting a little from this is what it must be. What's your interest? What do you stand to gain? Are you looking at, oh, is my uncle's property, my uncle this? So what's the interest? So we'll try to, get them to talk more inclusive in their discussion. And post mediation, so I want to talk about, I've talked about the preliminary stage, which is when they file. I talked about the preparation stage where we agree on virtually everything. Then the mediation, well, the mediator does the opening statements and introduces himself, tells them the rules, so they don't think you're talking before a judge or you are before a magistrate. And so, no, we're not here to judge a case. We're not here, you're not judging before you. So I'm here to facilitate. So you let them know what your role is, and you let them know you are is a voluntary process and all of those stuff, and also the grand rules. Then if, for example, at the end of the mediation, sometimes a mediation can be resolved within few minutes. I've done a mediation that the parties have been having dispute for like 4 years, and that matter was resolved within 20 minutes. I was shocked myself, so it could, then some other times it could take weeks, some other times it could take months. It depends on the case and the availability of the parties and also the mediator. And so usually if a case is resolved in mediation, if there are lawyers involved, you get the lawyers involved to join in drafting the settlement agreement. So the lawyers are carried along, and so they are there. Like, I wouldn't want to repeat what Uda said, like getting the people to repeating what they said just to be sure that we're all on the same page. So I'm not thinking something different. You say this, oh, this is what you've agreed. Whatever agreement it is, you get them to pen it down. Usually my style is I just, ask, okay, so you said number one, this issue number one, this has been resolved this way. Is that what you want? Someone said like that. So you get them to reach an agreement to that. And also if the lawyers are there, I usually just give them a piece of paper. Let's all draft together, have an understanding of what is agreed. And if you want to put it in a formal way, we get them to a day that they will come and sign, and that is it. And usually if it's a court-referred matter, once the mediation has been settled, all they need to do is to take the settlement agreements to the court and enter it as a judgment of the court. But if it's a working matter, like I said, we have working matters and we have court-referred matters. If it's a working matter, then it becomes a contract agreement that is binding by the first parties. And in Delta State, by Section 20 of Delta State Multi-Court Laws, 2012, that agreement is enforceable as judgment of courts. And just recently, we have Section 82 of the Arbitration and Mediation Act 2023. Thankfully, Nigeria just got the Mediation Act now as a formal document. But before it came, the Delta State already had a mediation law, the SNDC law, which also provide for that. But I think in addition, Section 82, subsection 2 of the Arbitration and Mediation Act 2023 also provide that settlement agreement reached by parties can be enforceable as consent judgment by the parties. So the process for us usually we allow after they sign, the mediator signs, they take the document and go. There's no issue. There is no need of going to register it as judgment of court at that moment, except so deemed to. But if on the day where the party is supposed to perform an act, it fails to perform the act, and so what the party or the lawyer comes back to us to say, oh, this is what we agreed at the multi-door, this is the terms of settlement, and it's not agreed to the terms of settlement. All you need to do is to come with a copy and an application to enforce. So we take you to the High Court registry, and you meet the registrar in charge, and they enter that terms of settlement as judgment of court. And the way you enforce a normal judgment of court, if you have a lawyer, the lawyer go and proceed into enforcing the terms of settlement as judgment of court. So that's basically the post-mediation stage. And so it's enforceable, whatever agreement that is reached. You know, it's voluntary, the process is voluntary, but the outcome is not voluntary. So if there's an agreement, it becomes binding and enforceable by law. Thanks to Section 82 sub 2 Arbitration and Mediation Act. And there's only one condition stated there in Section 83(1), which says it's mandatory for the mediator to evidence the settlement agreement before the settlement agreement can be relied on in court. And so for that settlement agreement, by virtue of that Section 83 sub 1 of the Arbitration and Mediation Act, it must be signed by a mediator. If the settlement agreement is not signed by the mediator and by the parties, it cannot be. So I will advise us to go back and just look. It's a small act, so it's not going to take much time. Look at the Arbitration and Mediation Act to guide you further, because now it's not a law in Nigeria, so it's not something you want to form ignorance about. So we need to know these things. We are lawyers, and it will help us better. Now I'll quickly run to the challenges in mediation. You know, like Uduak said, mediation is a very interesting process, but it has its own challenges, and sometimes it can be very challenging and very draining. And so I just went down difficult parties. Sometimes in mediation, you meet with some kind of difficult parties. And when I mean difficult parties, when I say difficult parties, what do I mean? You have some parties that are aggressive in communication. You know, I said I came from Delta State, and in Delta State, we are naturally aggressive in communication. And so you have, besides, there is already a bad blood between the parties. And, you know, so when they are communicating, most times, and this is face-to-face, two parties to themselves, sometimes it could get out of proportion. And so you get some kind of aggressive communication, negative body language, difficulty in managing emotions. And so, for example, when I say aggressive communication, the person is talking, is shouting, and is calling the other person abusive. There's only if you have agreed. There's there are ground rules which we've already have an agreement to say, oh, this is what must not be said, or this is what must be said. The person could go outside the rules sometimes because emotions have been, you know, juggled. And usually the essence of the ground rules is to always checkmate ourselves. And so come back and say, oh, we all agreed that we're not going to use negative languages on ourselves. As I know you're pained by what has happened. I know you're feeling so bad, even trying to remember the story, you're crying and everything. But could you please try to use some positive communication? Just don't go calling names, so that we can make some progress. And you know, sometimes they sob, they cry and everything. You just calm them down, get them some toys. So when you're mediating, make sure you have a lot of tissues around just to give to them, just to wipe their face. So you cannot just be looking at them when they are crying. You know, you allow them to talk. You can just pause. You just let them also know that you feel you're part of the process, you're part of the healing process, you're part of solving this problem. So that's why it's different from litigation. And so you encourage them also not to use negative language. You don't need to shout them down. You just sometimes, what I do is I try to calm the other party to say, don't worry, just ignore. But when I notice it's getting out of control, I have to break into caucus. Because that's one of the things you do in caucusing. And I've already told them that these are some of the things. When there is a deadlock in communication or negotiation, where there is emotion triggered that could not. So instead of allowing them to start fighting, I've had a mediation that they were fighting. I didn't know what to do. Like, who do I call? You don't have an orderly to be there for you, stuff like that. So at that sort of situation, you can break into caucus and have your one-on-one talk with the person, try to calm the person down. Please, you have to be very careful when you're in caucus. Don't say you said. Always do open-ended question. What if? Why are? When? What do you think? Sometimes they ask you, and I ask them, what do you also think? Because what is your mind? Just play it out, stuff like that. And sometimes they come like they kind of confide in you. And so you just say, okay, why don't you discuss that with that other party and see what he thinks about it? He may agree to it, or what do you think? I'm thinking that if I give this offer, it might be better, stuff like that. So you do those stuff in caucus. And so also sometimes some sarcastic statement like or unrealistic bargain. So maybe it's a business deal has gone sour and the person is saying, oh, I'm going to pay better, I'm going to pay over a period of 50 years. And this other person knows this person better. That's on that beautiful thing about mediation. I say, oh, you that they just paid so money for this contract that was done. You want to punish me, you start swearing and stuff like that. So you just try to calm them down. And if you're not able to calm them down, you take them into caucus. So that's one part of the challenge, difficult parties. And another challenge we have most times is no consent from the main parties in representative suits. And so, for example, your family mediation and the head of family, somebody comes and say, I'm the head of the family. And it's okay, can you get consent? Sometimes even the day of mediation that we've all agreed, they still don't come with a consent document. Like Uduak said, don't proceed if there is no consent because you may just be in a fitter journey, and can be very painful because meditation is very draining. And so you don't want to go on a fruitless journey. You want to be sure that they have consent. I have situations where they come with consent later and it's not stamped. And sometimes also you don't want to be too rigid so that everybody has come, some coming from maybe outside Delta. And I had a time somebody came all the way from abroad and he said his sister said he should come and speak for him. And I said, oh, you need to get a consent for your sister. And it becomes unreasonable to tell me you're going back except you get the consent. So that's we agree that, okay, we're going to comment something, and by the next date, please make sure, or if you can send it to my email, that would be nice, or the office email, or you can send a soft copy to me, just tell her to do a soft copy and send me through my email. Just try to be flexible because the process is flexible and just accommodate everybody. So you don't become, sometimes some mediators end up becoming the problem that needs to be solved. So you need to learn the skills of mediation. And because that's one of the grounds for refusal to enter the agreement as judgment by section 84 sub 1 of the Arbitration and Mediation Act. If there is no consent from the party, then the court will not. So there have to be consent, and you have to be sure that that consent is the right consent, because in Nigeria, sorry to use the word, we kind of lie. And so sometimes some people come with all kind of forged document and tell you this is the consent. Then while you're going on towards the end of the mediation, somebody comes and say, well, and we're not going on again. And you say, oh, why? Why are you not here? You say, well, I don't have consent and my boss. I say, you sent me a consent letter. You say, well, there was another person that gave me the consent, not my real boss. Stuff like that. You are not in the company to know who is the real boss and who should not be. And so you could have some of those as some of the challenges in mediation. Then apart from not getting consent, you also have issues of frustration of the process. And when I talk about frustration of the process, I mean refusing to attend scheduled session. You've had situations where there's an agreement for mediation to be fixed at a particular time and date, and on that time, few of the parties are around, especially if it's a multiple party, or if it's just two parties, one of the parties around, the other party is not around, no communication, nothing, no message, nothing. And you're just waiting. You felt, okay, let's give him 30 minutes, maybe we'll be coming. And thereafter, the person never came. And so it could be very frustrating. And the other party feels, oh, why am I wasting my time to come? What are you going to do? Are they not going to be order against him? Are they not going to be judgment against him for not coming? Since I came and he did not come, is the court not going to, like, okay, sorry, it's not really a court, like a court, so we cannot take any decision as it will. But I'm going to get across to find out why you didn't come. Probably. So for me, most times I try to cool their mind to say, oh, probably there might be an accident. Probably, he has children. You never can tell. Maybe something happened. Maybe he's even in the hospital. So let's not be too quick to judge. Let me reach out to him. But let's just have a further date and see how best we could do. I'm very sorry on behalf of the other party. but don't worry, I'm certain by the next date, we're going to make some further progress. Some kind of sweet way just to encourage them to keep coming. But sometimes it can be very frustrating, especially when there's no communication. You are prepared, set that day for the sitting and nothing happened, and trying to convince the other party. Then other challenge we have in mediation is getting a party to change his mind after reaching settlement agreement. And so before signing, and so it just came in, and the next thing is yeah, after discussing with my lawyer, I don't think I want to. Yes, I agree to that, but I don't want to sign any longer. I'm not signing. My lawyer said I should not sign. And he said, oh my God, what do you do? The truth of the matter is, if a party refuses to sign the settlement agreement or refuses to continue with the agreement, that ends the process. There's nothing you can do about it. Is one of the challenges of mediation. You cannot compare anybody to, you can coerce them, you can threaten them. And so you just try to appeal to them to understand why you are here, try to make them understand the aim of mediation, the purpose of mediation, the benefits of mediation. And if, for example, it's a business relationship, you make them see the reasons why they need to settle so they could continue with business. Unlike going to court, you may win in court. By the end of the day, you have lost your business colleague, you have lost money you will make in the next few years, you have lost referrals. You get the point. And so if it's a family mediation, you also want to make them see the advantages. If you want to keep the family together, your grandchildren, your children, this is your stepbrother or your brother or your uncle. Sometimes it's always better you talk it out, you chest it out and you move on. And also, another challenge we have is refusing to keep to the agreements. And so you may have parties agreeing to say, okay, I'm going to do XYZ, I'm going to do XYZ, they get it signed up, and on the day he has agreed to do that, is nowhere to be found. I think I had more of that in landlord-tenant issues and different issues. And you say, oh, I don't think I want to do it. Like, oh, I'm sorry, the process is voluntary, but the outcome is not voluntary. You have signed, everybody have signed. And so when they come, I just take them to the High Court to enter it as judgment of court and ensure that and get them and allow them to use a lawyer to their lawyer to proceed to apply for enforcement of it, because by virtue of section 20 of the Delta State Multi-Dock House and section 82 sub 2 of the Arbitration and Mediation Act 2023, such refusal does not hold any ground. As long as the parties have signed, except he's saying that he was coerced and he has evidence to show that that was not his will. But as long as they have signed, any document signed, any agreement reached by the party is binding, is enforceable in law. I will move, when I get to the last stage, I'll tell you even that it is also enforceable internationally. Any agreements reached in Nigeria via mediation. Now, the last challenge I want to address, and I want to address it, but please, lawyers, don't get angry with me. Let's just flow together on this. The last challenge we have in mediation is lawyers. Now, when I say lawyers, I'll tell you from experience that I've had more mediation and settlement with non-lawyers than with lawyers, because by the time we come, the problem is not that lawyers are problematic. No, the problem is lawyers don't understand the process. They don't understand, they don't have knowledge of mediation, and they don't understand the process. And so you have lawyers coming and even filing a response and telling you, couching the air to be arbitration. And sometimes I tell them, oh, I think, because usually, I think I jumped out when I was talking at the preparation stage, where there's an agreement. There's, in Delta State Multi-Dock Court House, there is a document you will sign whether you want arbitration, mediation, conciliation. So there are different doors to resolving dispute. And so if you have a stick to a mediation, I also emphasize and you will understand this is what it's about. And so most times the lawyer doesn't so, I'm sorry to say, most times I end up asking lawyers, do you have the Delta State Multi-Dock Court House laws? And 95% of the times they've not even seen it. They don't even know there's even a law. And so the next question is, so what are we doing here? Because you are coming and you're saying, objection, my lord. I say, sorry, I'm not your lord. I'm here to mediate. I'm a mediator. And I want us to work, because as a lawyer, we're supposed to assist the mediator in facilitating communication and negotiation between the parties in order for them to reach an amicable settlement. And so we're supposed to work together to see, because you are a lawyer, you understand better legally the case. I'm a lawyer, and I am a mediator. So I understand, I'm just trying to drive the parties to reach their own settlements. And so I do not expect you to come and say, oh, by law, he did this. Do you know by the law it is that, you are quoting sections of laws. I'm like, I understand, but we're here to see how we can exploit settlements. No, my client is not here for settlement. We want to go to court. Meanwhile, this client has come to say, oh, I really want the matter resolved. Thank you so much. And so most I encourage them to come with their lawyer because it's supposed to make things easy for us. But the challenge we have is that most times lawyers don't even have it. Now, I was asking someone recently, just 2 days ago, to say, oh, do you know there is a Arbitration and Mediation Act 2023 of Nigeria? And he said, but I expect, when I was practicing, the first time, anytime a law comes and it touches the judiciary, touches the courts, I want to get a grab of the law because people will come to you. How do you feel when your client comes and say, oh, I'm having a matter in the multi-law court? I say, don't worry, we're going there. And I have sometimes lawyers coming and wearing wig and coats, wig and, what do they call it now? Sorry. Wig and gown, okay, wearing wig and gown, and you say, oh, sorry, well, so you're wig and gown, just be free, we're here to talk, informal setting, we're just gisting, we could meet anywhere, we could agree to meet even in anywhere that the party feels is convenient for them, and it's also safe for the mediator. And so it's not a formal court sitting. So I think I have that challenge of lawyers not, personally, my experience, I have challenge of lawyers not understanding the intent and the purpose of mediation, and that affects the entire process. And so for those of us that are lawyers in this meeting, I want to really indulge us to please go back and try and have get a copy. If you're in Delta State and you live in Delta State, just go to any of the multi-law court houses in Delta State, in Asaba, Warri, Efru, Ughelli. Just tell them simply you need a copy of the multi-law court, and then we give it to you at no cost. You just go and make a photocopy of it and have it. It's handing, and you can. I downloaded the Delta State. I'm not in Nigeria at the moment, but I was able to get the Arbitration and Mediation Act, which is a law, a federal law, online. It's very easy. Just Google it and get it out. It will help you. So basically, I just want to talk briefly about the role of lawyers in mediation. As a lawyer, your role is to advise your clients about the availability of the process. And so usually, there are so many laws that insist on mediation, even for matrimonial cases. In as much as we cannot mediate on divorce issues, the law allows you to try to resolve, try to see whether they've been an amicable settlement. There can be an amicable settlement of the case before you proceed to court. And so you generally tell them, this is a simple case. You could also, why don't we try this first? If it doesn't work, then we could go to litigation. Since you have, especially when you notice that there are the kind of relationship between the parties is between two brothers. No matter how bad it is, so you have sold the family land and everything. Do we need to kill ourselves over that? We could be in court for the next 20 years. Then some matters you notice that it's just little money. And you don't even, especially when you have a client that doesn't have money, why pushing them into litigation? And they cannot even pay your fees. I remember one time when I was practicing, I had clients that when I come out from court, they have run away. And I get to the office and my boss said, we'll not go to the court again. And sometimes they come and they start counting money, 5 naira, or what they call that one, 20 naira. I'll be putting it in my hand. I'll just be looking at them until we have to change the rules in my office that we have to get our appearance fee in the office before we go to court, all of those stuff. So there's a client that cannot afford litigation. So those are the kind of people that we can encourage to do mediation instead. Then there are some clients that need to keep their relationship, husband and wife issues. And we know that they are still interested in themselves. There are some cases I do that they don't even get to sign, because I remember when I had a caucus and sometimes I just tell them I want to leave 2 of them to talk, because I noticed that they were already talking. They're kind of getting along. They've not spoken. Oh, you said this. I said, oh, I think you guys are getting along. Just let me give you 10 minutes. I'll be back in. Just let me go and get some water. And I just walked away. I came back and I discovered that they almost kissing, or they were already kissing. So this kind of matter, you go to court and you're arguing and raising the problem. Just allow me 5 more minutes. I think I should just leave and come back in 5 minutes. And the man said, don't worry, we have agreed to go home and talk and come back. And I never saw them. A few weeks later, I called and said, oh, you're supposed to have matters. Oh, she's not in my house. Hello. And so it's not every matter that must go to litigation. There are some matters that we should encourage resolving the matters by mediation. And also, we should advise, we are supposed to, as lawyers, we're also supposed to advise the parties, our clients, on have a pre-mediation meetings with our clients, prepare them for mediation. If you have a good understanding of the mediation process, you'll be able to talk to your client. This is what you're going to expect. This is how the process is being done. Look at the law. With the law, you'll be able to prepare them to participate in the mediation and also be part of the mediation process. I have situations where lawyers will not come. There are lawyers in the case, they will not come, and they will come on the day they want to sign to tell you that, sorry, I have filed a motion this morning. I said a motion in mediation. I say yes, I'm opposing what they've agreed earlier on. And I said, you don't need to file a motion. Let's sit down and talk. What's the concern? He said he agreed to this, but he did not understand better. And I said, that's why you're supposed to be here. You understand? You're supposed to participate in the process. You're supposed to encourage them. You're supposed to explain things to them. You know, but it wasn't coerced, and thankfully it wasn't coerced, and we got back into going back, like Uduak said, like going back again to start the process that we have already gone further from. But thankfully we were able to reach a settlement, and we didn't really change anything basically, you know. But as lawyers, you're supposed to be part of the process. You're supposed to be with your client. You're supposed to ensure your monies are being paid because you're supposed to be paid for your services. And so I always, some lawyers will tell you it's IQ dropping revenue. I tell them no, it's a faster way to make money, except you're not smart. Because a client comes, what do? You charge them, they pay appearance fee. If you feel that you're not going to stay, you want to put appearance fee. When I was working in Shell, we assign cases to lawyers, and you don't pay appearance fee. So you pay in one bulk, 500,000 is for this case, and you pay. So why are you not staying on appearance fee? And that is why we're not making some progress. So we have to change our mentality. We have to change our mindset, because mediation has come to stay. Mediation has gone beyond the local thing we're thinking. It's international. And Nigeria has adopted it as a law. So it's no longer like, oh, it's Delta State. Oh, is there a mediation law in Delta State? Do they have in Edo State? Do they have in Rivers State? No, there's a mediation law now in Nigeria that already set out the procedures. You understand? Then also lawyers should look in mediation. Lawyers should look beyond the legal issues and consider the dispute in a broader form. Because most times you just look at legal issues. What's the legal issue? So you have to think of the broader issues, the practical and wider concept that may include personal needs or interests. So you don't just close yourself to like, oh, we're looking at the legal issues. No, you also look at other issues as it relates to that case to see how you could help the parties. Because you just don't want, I've had cases that have bid and we got judgment and my client could not go back to the house. He ran away. And say, oh, so what do we do? We went back to resolve the matter. We have to sit them down to say, okay, so how do we, this is what the court has said. They say, okay, so the court has given judgment, come to the community, we're waiting for you. The man could not go to his house. You understand? So these are some of the things we should be doing and be thinking. Now, without saying much about the lawyer, so I don't get beaten. Anyway, I'm not in Nigeria, so you will not get me to beat. I'll quickly go to some ethical issues to consider when you're doing mediation. Again, I want to encourage us to go for training because it's basic. If you have trainings as lawyers, it's easier. But if you have some trainings, it's going to help your mediation process and help to sharpen your mediation skills. And so, first of all, the mediator is not a judge. The mediator is a facilitator. It's not a judge. It's not going to take a decision. It's not going to give judgment. It's not going to cast blame. It's not going to give legal opinion or advice or make decisions for the parties. And so I've had a situation where the parties ask me, what do you think? What's the judgment in this case? I said, no, there's not going to be judgment. It was going to be what we all agree at the end of the day. And so the mediator is not acting as a judge, but as a facilitator, and is helping the parties to communicate, assisting them to communicate and reach their own settlement. Also, not all cases are mediatable. And I repeat, not all cases are mediatable. There are some cases that you cannot mediate on. For example, core criminal cases, armed robbery, kidnapping, rape. You can't mediate on those ones. Like Uduak talked about someone that came and it's an illegal case, an illegal matter. You cannot mediate on an illegal matter. You understand? Then fundamental rights issues that are already provided for in the Constitution cannot be mediated on. They have to go to court. You understand? Then you have that can only by law can only be resolved by litigation. So you have, for example, like matrimonial causes hearts and probate issues, you know, or maybe issues that have to determine DNA tests, the legitimacy of a child, and you know, stuff like that. You cannot make an order at the multi-door court. You don't make orders. So we need the court to make an order. So no, we don't make orders. The parties agree. So if you need an order, you have to go to court to get the order done. So you don't get yourself forced into thinking, yeah, you judge and you're making orders that will not stand to see the light of day. So we need to understand these stuff. Then I won't say much about privacy because I know Uduak said that. But one beautiful part about mediation is that it's a private sitting. So it's confidential, it's private. You don't need the public to know what you're saying or what you're discussing. And it's a voluntary process. So you cannot be coerced or forced to do that. Then neutrality. In mediation, the primary ethical consideration in mediation is neutrality. The judge must be able to inform the parties that he is unbiased. Sorry, not the judge, the mediator must be able to inform the parties that he or she is unbiased, is impartial, and should help the party to earn trust for him or her. So how do they get trust? They are watching you. and you're allowing one person to talk, and the other party wants to say, you say, no, don't say anything. You know, when you start doing stuff like that, people start feeling like, so you need to help them to earn your trust. Even if the other person is unreasonable, it can be very difficult. Sometimes you might just break into caucus and start having caucus with them until you think it's necessary for them to meet together, because caucus may help. And you say, while you're in caucus, so now will say, this is what I say, what do you think? How best do we resolve this matter? I say, I think it can be, for me, this is the way, this is the way. You say, I don't try talking with this other person, but how you know you will not accept it? Okay, no problem, let's give it a try. Just when we have a meeting together, just tell me what you think is in your mind. Or do you want me to say it? So if I must say anything that was discussed in caucus, I must get a consent, the outright consent of that party to say it. Otherwise, I don't say what is discussed in caucus, and I don't leave them. I don't tell them what they should say and what they shouldn't say. So we should have that at the back of our mind. The other ethical consideration we need to think of in mediation is informed consent. The parties have to be told by the mediator. You know, I remember Uduak was talking something about when the preliminary stage, most times you don't get to see the experienced mediator, and so there may be some kind of, so but as a mediator, once you come in, you must let them understand, set out the ground rules, let them understand what mediation is about, let them know what their rights are, let them know they can walk away if they want to. So they have that informed consent that this is what we're doing. You let them understand what the advantage or disadvantage of the process is. So you don't hide anything from them, and they have that awareness. You know, the situation where you conclude a mediation and somebody comes to say, I did not even know we were doing mediation. They're like, how you be saying that? You get the point. And so you need to get that informed consent. Then also disclosure or honesty. So you must let the parties know if there's any pending relationship. You don't need to come to the multi-dot courthouse to do mediation. Any of the lawyers can be, if you are a certified mediator, even if you are not a certified mediator and you have the skills of mediation, you can do mediation with the parties. But then if you are doing mediation and one of the parties is your client, because even the arbitration and mediation did not say that it has to be done in the multi-dot courthouse. So as long as there's a mediator, so what makes you a mediator? I'll leave that for you to find that we are all lawyers. And so if you're a mediator, you can sit anywhere in your office, you can set up a mediation firm, even in your office. I think they do that a lot in Lagos. When you have an office, you have mediation, arbitration, and I'm sure you have different lawyers that are involved in that. So what do you do? In such situation, there's a tendency for you to have a relationship with one of the parties, probably the one that came to your client and said, I'm having a problem with my tenants, I want to push them out and I need us to go to court. So why don't we try to talk to him to get into agree to something that is okay for two of you so that you can live peacefully? That's what you want. Or if there are other issues, other interests you need to say that you guys can get it talking. You get the point. And so when that is the case, as a mediator, you find out that you already have an interest, or there is unequal relationship between the two parties. If the other parties agree, most times if it's an unequal relationship, maybe a lender and a borrower, matrimonial cases, husband and wife, landlord and tenant, all of these kind of cases, doctor and patient, that is lawyer and clients, they are not in evil relationship. And you have one of them as your client, which is the powerful party. There's a tendency for the other one to say, okay, no problem, I will come, because I don't have money to go to court, I will come. But even when they come, you try to make them understand that, this other person, the doctor in this portion or the landlord in this place, is my client, I know him. And he wants this case, but I feel we should mediate on this case. Do you want us to go on with mediation? If the person agrees, disclose your relationship with the other party before you, make sure you disclose your relationship with the other party before you commence. And also let the other party agree that in spite of that relationship you have, I'm ready to go on because I feel you'll be impartial from the way you're talking. So don't impose it on anybody. So if, for example, you are a mediator in a public office like I am in the multi-dot courthouse, and anybody comes, it happens to be maybe my spouse's friend or a relative I know or someone that I've done a case for, it's my duty as a mediator to let all parties know that, we had a relationship with my neighbor 20 years ago, or the mother was my mother's best friend, whatever kind of relationship, I have to do disclosure. So, and allow them to say, I don't know, I don't think with this I can go on with the case. I want to step them and want you guys to choose another mediator that will want to do the matter. I say, no, I think we are okay. Since we are going to be the one. So let it come from the parties and say, we don't have a problem. But if you don't disclose, no ground for invalidating that terms of settlement. Because that other person can come and say, bring issue of bias, and you discover later that this man has been giving you money. If the man gives you money for any reason, please disclose it that yesterday you sent me 20,000. I don't know, just to appreciate me. I should also let you know. You don't need to hide anything, because when it comes out later, it's going to tarnish your image and it's going to affect the entire process you are putting so much time through. Then also make sure that the parties have capacity, because if the parties don't have capacity, when I talk about capacity, I talk about having authority to settle, then capacity as in age. If you are dealing with two parties and you notice that one of them is a minor, you cannot go on to mediate, because a minor cannot enter a contractual agreement. So make sure they have party, because it's a ground for invalidating it. You can look at section 84, sub 1A of the Arbitration and Mediation Act. Then also, I want us to also understand that another ethical consideration is that mediators have immunity. As long as mediators are immune from the acts they perform in the course of mediation, as long as it is done in good faith. And so there's an exception. Your mediation was done in bad faith, you cannot be immune. You can look at section 81 of the Arbitration and Mediation Act. And so I'll go to the last topic I want to talk about for time, and that is future trend in mediation. And I started by saying that mediation has grown beyond where we met it. Presently, there are about over 100 countries in the world that have mediation law, inclusive of Nigeria, that just got it last year, 2023. And so they've over 100 countries in the world have enacted mediation law. And so that's one new trend. So it's growing so fast. Mediation is growing, the acceptance is increasing, and we need to quickly key into it before you are left behind. Also, you have to understand that mediation can be physical or visual. It can be done physically or visually. You know, pre-COVID, we didn't know we can do mediation virtually. We didn't know we can do so many things virtually. But presently, anything can be done. So they can file the process electronic filing, and they can even have the sessions virtually. Because sometimes in mediation, you have parties that are not within the same jurisdiction. They are not within the same town, the same states. Some of them are not even in Nigeria. So how do you mediate? Are you going to be waiting? And you know, one advantage of mediation is time saving. It's faster. It's a faster means of resolving disputes. Are you going to be waiting for eternity until that party comes from wherever it goes to? You understand? And so there is need to have virtual sitting. Like, I've left Nigeria for almost 2 years now, about 2 years now, and I can tell you that I've been having a lot of mediation cases, even in the UK here and even in Nigeria, because I come and I meet a lot of Nigerians, and that's another advantage I need us to talk about as lawyers. You have to explore our talent. I never knew I would use mediation to eat. I never knew I would make some money doing mediation. You know, but I have people, I just stumble on people and like, oh, you know, I have problems, there's a lot of problems. You know, once you're outside the country, you have, oh, I sent money home and somebody has not built the house. Oh, okay, no problem. Can I talk with the person that you're going to pay my charges? And I could mediate. You get the point. And so mediation can be done virtually, mediation can be done anywhere. So I don't need to be in Nigeria to mediate. I've been doing a lot of mediation, and mediation can be done anywhere. So we need to get that clear. Then mandatory mediation, you know, we'll be talking about mediation must be voluntary. It cannot be compelled. But I can tell you presently that there are some countries that have made mediation mandatory in some instances. So I'm going to go through it and I will tell you why. And so we have, for example, various countries have adopted mandatory mediation in some cases. For instance, in the United States of America, in California, they have mandatory mediation with respect to child custody and visitation. So if it's an issue that have to do with child custody and visitation, you must go for mediation. And also we have some kind of form of mediation in Australia, and we have in Singapore. In fact, if you have, anyway, I don't think we have this kind of issues in Nigeria where you have neighbors complaining of noise nuisance. Like in the UK, you cannot shout when it's 90, there are things you should not do, there are rules. And so such cases doesn't go straight to court, that's to be mediated. And so that's the law. Then in the UK presently, small claims cases up to £10,000. I think there's sometime this year they will commence making it compulsory for such matters to be resolved in mediation and not necessarily going to court. And so if you have any small claim cases from £0 to £10,000, there is no need going to court. You have to do it in you have to get it mediated in the UK. So those are the laws. And also I want to also understand that, you know, I said earlier on when I started talking that mediation can be at before going to court, during the pendency of the case, and even after conclusion of the case. And so my authority is, we have the Court of Appeal Mediation Program, 2016, Rule 16. And there's the amended Court of Appeal Rules 2021, and Rule 16 also of that section. So if you check 2016 Court of Appeal Rules and 2021 Court of Appeal Rules, it gives power to parties after a case has been decided in the High Court to also resolve their matter using ADR mechanism, as mediation is one of the mechanisms. And so even after a matter has been concluded in courts, the new trend now is the matter can also be mediated at the Court of Appeal. And that is also the trend at the Supreme Court. But we have the Supreme Court. I don't know how many of you have seen the Supreme Court's mediation rules 2010. That rule came up since 2010, and Rules 2 of that rule says that all civil suits pending before the Supreme Court, which can be resolved by mediation as the CJ deems it appropriate. So if the CJ feels that this case, instead of wasting our time doing this case, we're going to set up, and usually they even have their judges that sit as mediator. And also, that's why you see judges are also learning the skills of mediation, because if you're going to sit as mediator, you're not going to sit as a judge, you're going to sit as a mediator. So the Supreme Court Mediation Rules 2010, we also have the Court of Appeal Mediation Program 2016, and the amended new one of 2021, Rule 16, that provides for mediation at the Court of Appeal and the Supreme Court. So mediation doesn't just end here. Now, just recently, so like I said, I talked about the mandatory mediation. Even though the mediation is mandatory, the process is voluntary. So you could have a mandatory mediation that say, oh, everybody must do X, Y, Z. You must go to mediation. But in the mediation sitting, nobody is being coerced. There's no judgment given. So the parties are allowed, they have that, they are allowed to negotiate and talk things out themselves. Do you understand? Then lastly, I want to mention the Singapore Convention on Mediation. I don't know if we have seen it or we've read about it. And so the is a United Nations Convention on International Settlement Agreement resulting from mediation. And so it's called the Singapore Convention on Mediation. It provides that all resolution of international dispute by mediation, you understand? It provides that every resolution reached by mediation, international dispute reached by mediation, can now be recognized and enforced internationally. So presently we have 57 countries who are signatory to this United Nations Convention on Singapore Convention on Mediation, and Nigeria is one of the signatories. And what that simply means, Nigeria signed and accepted on the 23rd of November 2023, so it's quite recent. And then we have 2 other countries that have accepted to it recently. And so what that simply means is, a case that have been mediated in Nigeria, if one of the parties is in the UK, or is in America, or is in Canada, or is in Australia, or is in any country that is a member state of that convention, all you need to do, that settlement agreement can also be filed at the court in that jurisdiction and enforced as judgment of that court. So that's the new trend. So that's why I said, if we're not looking at mediation now, then you are old school, because things have moved beyond. So you could have mediation in Nigeria, in whichever locality you are in Nigeria, and that mediated agreement can be enforced and registered in any court within the 57 countries that are presently signatories, and we also have other countries still signing to it. Thank you very much for your time.
You're welcome. Thank you. Thank you for doing justice to the topic. We really appreciate the well-researched lecture. I don't know if there are questions. If we have questions, please, you could just put them down so that they will take the questions one after the other. Okay. It's Madam Chair around. Madam Chair, would you like to contribute?
It's been so interesting, honestly. But at this time, I think the day is fast spent. Can you hear me?
Yes.
Yes. So I just want to thank all the speakers. Thank you so much for, these insightful and very detailed. Okay, my light is back now. Very detailed presentations. So thank you. I have no questions, no comments. Thank you.
Thank you.
Nobody seems to be asking. I guess it was very explicit. In the absence of any other question, I would like to move for us to close this session. But before I go, I want to appreciate our speakers. Thank you, Kewe. Thank you, Uduak, for making this session a wow session. Thank you for the exposition. Thank you for the research. You all put your heart into it. That's why we have what we have today. We are really, really glad that you turned up. For everyone who attended, thank you. This program would just not be complete without you. I can see Oluwabumi there, Oghenekevwe Orighoyegha, Yusuf. I can see Munira Achewu, Namdi Oyekwe, Maya Basi, Grace Edogbo. One thank you. I always saw one thank you. Ovoke, Seto, Mary, Aworiwo, Janet, Annabella Ndidi. This program will not be complete without your being here. Thank you all for participating. We look forward to another lecture sometime soon. We'll spread the news when it's time. Thank you and God bless you all. Have a lovely day.
Let me just have a last talk.
Okay.
Sorry, let me appreciate my DJ again. He's a great man. He's one of the people I'm in the UK today. And so amazingly, I just informed him a fortnight ago, and he's been here since the beginning of the meeting. I know he's a very busy person. The Director General of Delta State Multi-Door Court House, Nnamdi Oyekwe, and I appreciate your presence. Thank you. And he also shared it even in our forum, encouraging even the judges and the lawyers in Delta State Multi-Door Court House. So thank you, sir.
Thank you, sir.
Thank you so much, sir. Thank you so much for being with us throughout. We are very appreciative. Thank you so much.
Thank you, and God bless you.